Hello once again. In this video, we will discuss complex crimes under Article 48. Now if you will remember in one of our videos, dito sa criminal liability, we mentioned na aberratio ictus is one of the possible situations when the wrongful act done is different from that which is intended. Now under Article 4 Paragraph 1, na-mention natin ang complex crime. Kasi sa complex crime, maaring magkaroon ng complex crime under aberratio ictus if the single act constitutes two or more grave or less grave felonies. So sa example natin dito, the single act of shooting with a gun produced a grave felony and a less grave felony, kaya nagkaroon ng complex crime. At sa isa pa nating video, wherein we discussed the classification of crimes according to their gravity, na-mention natin na one of the reasons why we need to study Article 9 is para malaman natin kung pwedeng i-complex ang mga crimes na nakomit. That is why we need to know whether the crimes committed are grave felonies, less grave felonies, or light felonies. And the only way to do that is to know the penalties of the crimes. Because if you know the penalty, then you will be able to tell whether it's a grave felony, a less grave felony, or a light felony. Before we proceed to the discussion proper, let us first discuss some of the basics. Now, what do we mean when we say plurality of crimes? It consists in the successive execution by the same individual of different criminal acts upon any of which no conviction has yet been declared. So, successive execution, sunod-sunod ang pag-commit niya ng different criminal acts. That's why we refer to the plurality of crimes. We have formal or ideal plurality, and we have real or material plurality. When we say formal or ideal plurality, there are different criminal acts but only one criminal liability. Meaning marami siyang nakomit na crimes, pero iisa lang ang liability niya. Dito naman sa number 2, there are different crimes in law, and the offender shall be punished for each and every offense he committed. Gaya ng number 1, sa number 2, marami din siyang nakomit na crimes. Pero, unlike dito sa number 1 kung saan there is only one criminal liability, sa number 2, he will be liable for as many crimes as he committed. So, magiging liable siya for each and every crime or offense that he committed. Let us provide some examples here. Under number 1, formal or ideal plurality, Pedro wanted to kill one, so he waited for him in the corner where one usually passed by. When he saw one, he shot him with a gun. Because of poor aim, he missed one and the bullet landed on a bystander who died as a consequence. Now, na-mention natin na under formal or ideal plurality, there are different crimes committed, pero there is only one criminal liability. So dito, the crimes committed are attempted homicide against one, and homicide against the bystander. Since there is only one criminal liability, his liability shall be governed by Article 48, and that is the penalty for homicide in its maximum period. And this is Article 48, wherein it provided for the penalty when it comes to complex crimes. Example of number 2, real or material plurality. A hacked B with a bolo and killed him. A also hacked C, B's friend, with the same bolo and killed him. Sa number 2, marami ding crimes ang nakomit. But unlike number 1, sa number 2, the offender shall be liable for each and every crime na nakomit niya. So sa number 1 example kanina, although maraming crimes na nakomit, attempted homicide and homicide, ang liability niya lang is for homicide in its maximum period. Pero dito sa number 2, he will be liable for each homicide or murder that he committed. So dito, 2 counts of homicide for the deaths of B and C. A shall be punished for each and every crime that he committed. What are the examples of formal or ideal plurality? We have 3 complex crimes under Article 48, which is our topic in this video, special complex crimes, and continued or continuous crimes. Now, under complex crimes, we mentioned that there are 2 kinds. We have compound crime, when a single act constitutes 2 or more crimes, and we have complex crime proper, when an offense is a necessary means for committing the other. In special complex crimes, it is otherwise known as composite crimes. So kapag may na-encounter kayo na composite crimes, it is referring to special complex crimes. Now, what are special complex crimes? In substance, is made up of more than one crime. Kasi nga, under siya ng formal or ideal plurality, so maraming crimes na nakomit. Gaya ng complex crimes, madami ning crimes na nakomit dito sa number 2. But in the eyes of the law, is only a single indivisible offense. The law specifically fixes a single penalty for 2 or more offenses committed. Sa number 1, medyo general ang pag-impose ng penalty. Kasi under Article 48, the penalty shall be for the most serious crime, the same to be imposed in the maximum period. Pero sa number 2, it is the law itself which specifically provides for the penalty. Meron talagang particular na penalty para sa commission ng special complex crimes. Example, one night, while A was walking, B appeared and pointed a gun at A. B demanded A to give his cell phone and wallet. A fought back, so B shot him. A died. So dito, merong na-commit na robbery at meron ding na-commit na homicide. But these two crimes are covered by Article 294. When homicide is committed by reason or on occasion of robbery, meron tayong special complex crime of robbery with homicide. At since na-mention natin na the law specifically fixes a single penalty or yung law mismo ang nag-provide ng penalty for the commission of special complex crimes, titignan natin yung law under Article 249. And the penalty of reclusion perpetua to death shall be imposed. So meron talagang specific penalty for the commission of special complex crimes. And then we have continued or continuous crimes, one where the offender performs a series of acts violating one and the same penal provision committed for the same criminal purpose. Gaya din ng number 1 and number 2, marami ding crimes na nakumit. Pero, yung crimes na nakumit ay pare-pareho lang. They refer or pertain to the same penal provision. Kasi dito sa continued and continuous crimes, the criminal offender has only one criminal purpose or goal in mind. Example, A learned that his neighbor B went out of town for a vacation. B was the caretaker of game roosters owned by different people. A went to his neighbor's backyard and stole 3 roosters belonging to X, Y, and Z. Now dito, merong single offense of theft. Kahit na marami pa siyang crimes na nakumit. Nakakumit siya ng theft against kay X dahil sa pagnakaw ng rooster niya. Nakakumit din siya ng theft against kay Y dahil sa pagnakaw din ng rooster niya. And against kay Z, meron ding theft na nakumit si A. Pero kahit na merong crimes na nakumit sa iba't ibang tao, there's only one liability here. And that is for the crime of theft. Another example of continued crime. A sent an anonymous letter to B which read, "If you will not deposit 5,000 pesos to this account, I will kill your family and burn down your house." B deposited 2K. 1 month later, A sent another letter demanding the balance of 3K accompanied by the same threats. B deposited 2K. 2 weeks later, A sent another letter asking for the remaining 1K with the same threats. This time, he was caught and arrested. So kung mapapansin ninyo, 3 beses nagpadala ng letter si A at pare-parehong tenor, threatening B to kill his family and burn down his house. So merong threat. Nung una, nagdeposit lang si B ng 2,000 pesos. And then another 2,000 pesos. So kahit pa may 3 letters, they are all in relation to one criminal purpose, and that is to extort the amount of 5,000 pesos from B. Ang crime na nakumit dito ay only a single offense of grave threat. Under Article 282, grave threat is committed by any person who shall threaten another with the infliction upon the person or honor or property of the latter or of his family of any wrong amounting to a crime. So dito, although maraming letters na pinadala si A and bawat letter merong corresponding threat to kill B's family and burn down his house, merong pa ring single offense of grave threat. So iisa lang ang kanyang criminal liability. And since gumamit siya ng letter, ang penalty niya is i-impose sa maximum period. Kasi nga, if the threat be made in writing, the penalty shall be imposed in its maximum period. And we already discussed this in one of our videos covering grave threats under Article 282. Pakiwatch na lang pag may time kayo. Perhaps you may have already encountered the concept of continuing or transitory crime. Itong continuing or transitory crime, it is different from continued or continuous crime. Let's compare them side by side. Dito sa continued or continuous crime, it is a single crime consisting of series of acts violating one and the same penal provision committed for the same criminal purpose or resolution. So kung matatandaan ninyo yung example natin kanina, yung tao na nagnakaw ng 3 game roosters, he committed series of acts kasi 3 manok ang kanyang ninakaw. And he violated one and the same penal provision, that provision which deals with the crime of theft. He committed the series of acts for the same criminal purpose or resolution. Iisa lang ang kanyang goal or iisa lang ang kanyang purpose, and that is magnakaw ng maraming manok. Dito naman sa continuing, transitory, or moving crime, it is a crime that may be prosecuted and tried not only before the court of the place where it was originally committed or began, but also before the court of the place where the crime was continued. In other words, dito sa type ng crime o sa uri ng crime na ito, it refers to the place where you may file the criminal case, kung saan i-hear at i-try yung kaso. Kapag nakakommit ka ng crime na ito, pwede siyang i-file sa lugar kung saan nagsimula yung crime at pwede mo rin siyang i-file sa lugar kung saan ipinagpatuloy yung crime. There are many places you can file the criminal case. Kasi sa criminal procedure, pag nag-aral na kayo ng criminal procedure, you will eventually learn that venue in criminal cases is jurisdictional. Now, continued continuous crime is a term used in criminal law, while continuing transitory or moving crime is a term used in criminal procedure. So you will encounter continuing transitory moving crime when you will proceed to the study of criminal procedure. Just a short glimpse of criminal procedure. Under Rule 110 of the Rules of Court, particularly Section 15, the place where the action is to be instituted. Dito sa municipality or territory where the offense was committed, kung saan mo na-commit yung crime, or where any of its essential ingredients occurred, kung saan nangyari yung mga elements niya. Examples, yung sa cheque. Kung yung cheque na yun ay dinro, in-issue at dineliver sa Manila, pero tumalbog naman sa Batangas, under criminal procedure, since violation of BP 22 or the bouncing checks law is a continuing or transitory crime, then you may file the case sa Manila kung saan drino, in-issue at dineliver yung cheque, or pwede mo ring i-file yung case ng BP 22 sa Batangas kung saan tumalbog yung cheque. Another example, the victim was kidnapped in Cebu City and was brought to Palawan where he was locked up until the ransom was paid. So dito, nagsimula yung crime sa Cebu City at pinagpatuloy sa Palawan. Now, under continuing or transitory crime, under criminal procedure, pwede mong i-file yung case sa Cebu City or sa Palawan. Kasi nga, again, venue is jurisdictional. So there you have it, ladies and gentlemen, the formal or ideal plurality, the examples of which are complex crimes under Article 48, special complex crimes, and continued or continuous crimes. Let us now proceed to our main discussion, Article 48 or complex crimes. There are two kinds of complex crimes. We have compound crime and complex crime proper. Now, there is a compound crime when a single act constitutes two or more grave or less grave felonies. And there is a complex crime proper when an offense is a necessary means for committing the other. Now, a complex crime is only one crime. So here, although there are two or more crimes committed by the offender, in the eyes of the law, there is just one crime committed. Example, A was heartbroken because B, the most beautiful student in the campus, was already in love with C. A wanted to kill C, so he bought a gun and looked for C. When he saw C walking, A aimed his gun at him and pulled the trigger. Because of poor aim, A failed to hit C and instead hit another student who was busy studying. The student became blind because of the injury. Now, there is a complex crime here of attempted homicide and serious physical injury. In other words, A committed two crimes. A committed the crime of serious physical injury against the student who became blind, because under Article 266, if the injured person shall become blind, then you are liable for serious physical injury. He also committed the crime of attempted homicide against C, because there is an intent to kill and he already commenced the execution of the felony directly by overt acts. Now, there is only one penalty for the commission of complex crime, and the penalty is provided under Article 48. The penalty shall be for the most serious crime, the same to be applied in its maximum period. Now, in this example, there are two or more crimes committed by A. We have to know which of the two crimes is the most serious crime, so we will know what penalty to impose. Because under Article 48, you will impose the penalty for the most serious crime to be applied in its maximum period. Now, if we look at Article 249 for the crime of homicide, the penalty is reclusion temporal. But take note that Article 249 deals with consummated crimes. In this crime committed by A, it is in the attempted stage. So we have to refer to Article 51, which is the article which provides guidance with respect to attempted crimes. Here, if there is an attempted crime, the penalty shall be lowered by 2 degrees. And to know which penalty is higher or lower, you have to refer to Article 71. This is now the penalty for consummated homicide. And if you refer to Article 51, you have to lower it by 2 degrees. And if it's lowered by 2 degrees, the result will be prison correctional. So prison correctional will be the penalty for attempted homicide. Now, what about serious physical injury? Now, serious physical injury, if the injured person becomes blind, then the penalty shall be prison mayor. This is now the penalty for serious physical injury. Now, if you compare them side by side, we can immediately say that serious physical injury is the more serious crime. Let us now discuss the first kind of complex crime, which is the compound crime. There are two requisites for compound crime. The first is that only a single act is performed by the offender. It means na gumawa lang siya ng iisang act. Hindi series of acts, hindi more than one act, but only a single act. Example, ito yung example natin earlier. And na-mention natin na dito, A committed a complex crime of attempted homicide and serious physical injury. Yung single act dito ay yung pamamaril, yung pagkalabit niya ng gantilyo, the single act of pulling the trigger. And dahil sa single act na yon, nagkaroon ng two crimes, attempted homicide and serious physical injury. And because it is a complex crime, it is only considered as one crime. Another example, A's neighbor was having a party and some visitors were singing karaoke. They kept singing the song Pusong Bato over and over again. With his patience running out, A went outside and threw a high explosive hand grenade at his neighbor's house. One was killed and two suffered minor injuries. Now there is a single act here at ang iisang act na yun ay yung paghagis ng granada, throwing a high explosive hand grenade. And because of that single act, nagkaroon ng madaming crimes. The single act produced more than one crime. Another example, A accused B of cheating in their PUBG tournament, so he vowed to kill the latter. A borrowed the submachine gun of his father and went to the cafe to search for B. When he saw B, he pulled the trigger and 20 bullets fired in automatic succession. He managed to kill B, but he also hit two of his friends who were hospitalized for 2 months. Ang question dito is, merong bang single act or series of acts? Nakasalalay ba sa bilang ng bala ang number of acts na nakumit? Kapag marami bang bala na lumabas at nag-fire, ibig sabihin ba marami ring acts na nakumit? This has already been decided. And the court said that even though many bullets were discharged from the chamber because it's a submachine gun, there is still a single act of pulling the trigger. Kaya dito, we have a complex crime of murder and serious physical injuries. Now let's go to the second requisite of compound crime, that the single act produced two or more grave or less grave felonies. In our previous example, dito, merong complex crime of attempted homicide and serious physical injury. So kailangan nating alamin kung ang attempted homicide ba at ang serious physical injury ay pasok sa definition ng grave felony or ng less grave felony. At para malaman natin yan, we have to consult Article 25 in relation to Article 9. Ito ngayon ang mga grave felonies, less grave felonies, and light felony. Itong grave felony, it's a felony which the law attaches the capital punishment, itong death, or penalties which in any of their periods are afflictive. Ito namang less grave felony, those which the law punishes with penalties which in their maximum period are correctional. At dito sa light felony, those infractions of law or the commission of which the penalty of arresto minor or a fine not exceeding 40,000 pesos. So yan ngayon. Ang penalty ng attempted homicide is reclusion temporal. But we have to consider the stage. Dito sa attempted homicide, it's in the attempted stage. So under Article 51, you have to lower the penalty by 2 degrees. And pag mag-consult naman kayo sa Article 71, sinasami doon na 2 degrees lower ng reclusion temporal ay prison correctional. And kung titignan naman ninyo sa Article 25, prison correctional ay nabilong sa correctional penalties. Therefore, attempted homicide is a less grave felony. Dito naman sa serious physical injury, ang penalty under Article 263 ay prison mayor. So kung titignan ninyo ang Article 25, ang prison mayor ay pasok sa afflictive penalty. Kaya ngayon, ang serious physical injury ay isang grave felony. So na-comply niya ang second requisite, which is that the single act produces two or more grave or less grave felony. Dito, yung single act niya ng pamamaril ay nag-produce ng less grave felony at ng grave felony. Sa other example naman natin, itong naghagis ng granada, he committed the complex crime of murder and multiple attempted murders. So they are both grave felonies. Kasi yung mga penalties nito, pasok sa afflictive penalties. So itong murder at attempted murder, pasok sa grave felony. At dito naman, sa last example natin, he also committed a complex crime of murder and serious physical injuries. Sa murder kasi, under Article 248, the penalty is reclusion temporal in its maximum period to death. So pareho silang grave felony kasi itong sa serious physical injuries, under Article 263, the penalty is prison mayor, which is pasok pa rin sa afflictive penalties. That's why they are both grave felonies. There is a question here. How about light felony? what is the treatment of light felony? Kasi kung titignan natin yung second requisite, only grave or less grave felonies. So ibig sabihin, hindi natin pwedeng i-complex ang light felony with the other crimes. Light felonies, which are produced by the same act, is either absorbed by the grade felony. For example, when Maria got drunk, Pedro volunteered to bring her home. But instead of going to Maria's house, Pedro brought Maria to a motel where he raped her. Maria also suffered slight physical injuries on her genital organ. So kung titignan ninyo, dalawang crimes ang nakomit, rape and slight physical injuries. But if you look at slight physical injuries, it's a light felony. So anong mangyayari sa slight physical injuries? Pag tinignan nyo kasi yung case, itong slight physical injuries, it's a necessary consequence of the violence or force employed upon Maria. Therefore, it is absorbed by rape, or light felonies will be punished as separate offenses. Now, how will the crimes resulting from fault or culpa under Article 65 be considered? Here comes now the famous case of Jason Ivler versus Modesto, GR number 172716. Now, noong 2004, nagkaroon ng aksidente. Itong si Jason Ivler nakabangga. And then, isa sa mga passengers namatay. Yung isa naman is nag-sustain ng slight physical injury. And of course, na-damage yung sasakyan. Nag-file ngayon ng case for reckless imprudence resulting in slight physical injuries, covered by criminal case number 82367, at isa pang case, reckless imprudence resulting in homicide and damage to property, under criminal case number 82366. Under sila sa Article 365 of the Revised Penal Code. Now, bakit magkaiba? Kasi kung titignan ninyo, this is a light felony. Ito naman sa homicide at saka damage to property, they are either grave or less grave felonies. Kaya, they are complexed with each other. Samantalang ang slight physical injury, which is a light felony, hindi siya kinomplex. Kaya, magkaiba yung kaso na to. Iba yung final sa slight physical injuries at iba din yung final sa homicide and damage to property. Now, ano ngayon ang sinabi ng court sa case na to? Dapat bang paghiwalayin? Do we need to follow the rule that light felonies should be treated separately and thus should be treated as a separate offense? Ang sabi ng court, hence, we hold that prosecutions under Article 365 should proceed from a single charge regardless of the number or severity of the consequences. Tignan ninyo, single charge regardless of the number or severity of the consequences. Kahit pa gaano kadami yung resulting injury because of Article 365 or dahil sa kapabayaan mo or dahil sa negligence mo or imprudence, there will only be a single charge. Dapat pagsamasamahin silang lahat sa iisang information or sa iisang charge. In short, there shall be no splitting of charges. So kung halimbawa nakabangga ka, gaya nitong case, and merong namatay and merong nasugatan, merong light felonies doon at merong grave or less grave, hindi mo sila isa-separate. Kailangang i-file mo sila under a single information. Only one information shall be filed in the same first level court. So you don't have to follow the rule in complex crimes na kapag light felony, you treat it separately. Kapag ang felony na yon is under Article 365, fault or culpa. It excludes crimes punishable by special laws. Kasi nga, kung titignan natin ang second requisite, it mentions felonies. Felonies, by definition, are acts or omissions punishable by the Revised Penal Code. So kung special law siya, it is not punished by the Revised Penal Code, hindi siya felony. Kaya, you will not complex crimes in violation of special laws. But you have to remember that there are special laws which are mere amendments to the Revised Penal Code, gaya ng Republic Act 8353 or your anti-rape law. It's an amendment of the rape provision under the Revised Penal Code. So kahit pa special law siya, inamend niya naman yung Revised Penal Code. So it is considered still as a felony kasi it's an amendment. Example, A dreamed of having a gun, so he planned to steal the firearm of his neighbor who was a police officer. He managed to steal the gun while the police officer was sleeping. So dito, may dalawang crimes siya na commit. The theft of firearm and the other one is illegal possession of firearm. Now they are two distinct crimes kasi nga hindi mo sila pwedeng i-complex because illegal possession of firearm is a violation of a special law. Let us now go to the second kind of complex crime, which is complex crime proper, when an offense is a necessary means for committing the other. There are three requisites. First, that at least two offenses are committed. So kailangang merong dalawang crimes or higit pa sa dalawa. Kasi nga, this is under formal or ideal plurality, which means that there are two or more crimes committed. The second one is that one or some of the offenses must be necessary to commit the other. Take note of the word necessary. So kinumit niya yung isang crime in order to facilitate the commission of the other crime. Na ano bang ibig sabihin ng necessary? Does necessary mean indispensable? Necessary does not mean indispensable. Kapag sinabi nating indispensable, ganito yan. Example, Balmond envied Claude because of his looks and skills. While Claude was sleeping on the balcony, Balmond threw a hand grenade into the balcony, which exploded a few seconds after hitting the floor. Claude died as a result. Now dito, there are two crimes committed, kung titignan ninyo. First is murder, and the second one is crimes involving destruction under Article 324. Now, any person who shall cause destruction by means of explosion, yan yung ginamit niya na means. Crimes involving destruction. Pero sa case ba na to, makukumit niya ba ang murder without explosion? Hindi. Kasi dito, naging murder siya dahil sa use of explosion. Kasi nga, di ba, under Article 248 sa murder, by means of explosion. Kapag hindi siya gumamit ng explosion, hindi magiging murder. Kasi kailangan ng explosion dito na case. So kapag hindi siya gumamit ng explosion, malamang it's just a simple case of homicide. Pero gumamit siya ng explosion. At meron ding particular provision under the Revised Penal Code prohibiting the use of explosion. And that is Article 324. Ang ibig sabihin ba nito, magkakaroon ng dalawang crimes, murder at crimes involving destruction? The answer is no. Kasi pag sinabi mong indispensable, itong use ng explosion, it is an indispensable means to commit murder. Ibig sabihin, kung walang explosion, walang murder. And because it is an indispensable means, it is an essential ingredient of the crime of murder. And because it is an essential ingredient of the crime of murder, it will not be treated separately. Hindi magkakaroon ng another crime involving destruction. Kasi nga, it is already absorbed by the crime of murder. Now, that is the meaning of indispensable means. Now, how about necessary means under the second requisite of complex crime proper? Pag sinabi mong necessary means, yung crime na kinumit mo siya in order to facilitate the commission of another crime para mapabilis or mapadali ang pagkumit mo ng other crime. Hindi indispensable. Kasi makukumit mo pa rin yung other crime na yon kahit na hindi ka nag-resort sa crime na ginamit mo. Pero, mas napadali ang pag-commit mo ng crime na yon dahil sa crime na ginawa mo. In other words, yung crime na ginawa mo, it facilitated or it helped you commit the crime that you want to commit. For example, Maria was abducted by Pedro and was carried away by force to a secluded place. Upon arriving at the said place, Pedro raped Maria. Now dito, it's a complex crime of rape through abduction. Inabduct niya si Maria para ma-facilitate yung pag-commit niya ng crime ng rape. Pwede niya pa rin i-rape si Maria without abduction. Kasi kung indispensable siya, hindi siya magiging complex crime proper. Nagiging complex crime proper lang dahil sa inabduct niya, mas napadali ang pag-rape niya kay Maria. So it is a necessary means of committing rape. Another example, Maria gave Pedro 20,000 pesos to pay the BIR, the capital gains tax. Instead of paying, Pedro forged a BIR receipt to make it appear that he paid 20K when in fact he pocketed it. In this case, he committed complex crime of estafa through falsification of public document. Makukumit niya pa rin ang estafa against kay Maria kapag gumamit siya ng ibang means ng panloloko. Pero dito, mas napadali or mas na-facilitate yung pag-commit niya ng crime ng estafa dahil sa pag-falsify niya ng public document. That is the import of the second requisite. Now let's go to the third requisite, that both or all of the offenses must be punished under the same statute. So kung titignan natin sa first example, both of these crimes are punished by the Revised Penal Code. At ito rin, estafa and falsification. They are both punished by the Revised Penal Code. Rules to remember under Article 48. First, one information should be filed when a complex crime is committed. Now under Criminal Procedure, Rule 110, particularly Section 4, an information is an accusation in writing charging a person with an offense subscribed by the prosecutor and filed with the court. So under the first rule, kailangang isang information lang ang i-file kapag merong complex crime. So sa complex crime, maraming crimes na nakumit but it is considered as only one crime. Kaya one information lang ang i-file. So this is an example of information. Dito sa information, malalaman ninyo kung ano yung case na final against sa accused. So ang laman nito is eto, that on or about the 29th day of January 2012 in the city of this place, the above named accused did then and there willfully, unlawfully, and feloniously rape the person of Marie Juana Lopez. So that is an example of an information. Under Section 13, a complaint or information must charge only one offense. So sinasabi dito sa Section 13, kailangan kapag merong information, iisang offense lang ang dapat i-charge. For example dito, sa case na to, itong si Jimmy Tabio, he was charged for 3 counts of rape. So 3 beses siyang nanggahasa, 3 beses siyang nang rape. Dito sa information, between June 13 and June 28, 2002, the said accused did then and there unlawfully, feloniously, and willfully have carnal knowledge of mentally retarded AAA. So usually pag mga minor, itatago ang name nila, that's confidential, by means of force and intimidation 3 times. So nang rape siya 3 times. Under Section 13, kailangang isang offense lang bawat information. So dito, since there are 3 counts of rape, dapat bawat count ng rape ay merong information. So there should be 3 informations filed. And non-compliance of this rule can be a ground for a motion to quash. So the accused may move to quash. Pag sinabing quash, to invalidate the information, ipawalang bisa ang information. Because of this, letter F, that more than one offense is charged. So paano sa complex crime? Since there are 2 or more crimes committed sa complex crime, ibig sabihin ba maraming information ang i-file? Hindi, because of rule number 1. Kapag complex crime, 1 information should be filed. Now, does this not violate the rule in criminal procedure? Hindi. Kasi kung titignan ninyo ang Section 13, a complaint or information must charge only 1 offense, except when the law prescribes a single punishment for various crimes. So, ang tinutukoy dito ay yung complex crimes. And tignan nyo din dito sa Rule 117, a motion to quash. Diba nakalagay that more than one offense is charged, except when a single punishment for various offenses is prescribed by law. Kasi nga, di ba sa complex crime, although the offender committed 2 or more crimes, he only has 1 criminal liability. Kaya iisang information lang ang ifa-file sa kanya. Second rule, Article 48 does not apply when the law provides 1 single penalty for special complex crimes. Now, kung matatandaan ninyo, balik tayo sa formal or ideal plurality. Number 2, we have special complex crimes. Ito yung tinatawag nating composite crimes. Now, these are the example of special complex crimes. Robbery with homicide under Article 294. Ang kaibahan ng complex crime at saka special complex crime is that sa special complex crime, the law itself provides for the penalty. Sa complex crime naman, under Article 48, ang penalty ng complex crime is the penalty for the most serious crime in its maximum period. Pero sa special complex crime, ang batas mismo, there is a specific provision of law, halimbawa under the Revised Penal Code, punishing special complex crimes, gaya ng robbery with homicide. Makikita nyo yan sa Article 294. And may particular na penalty dyan, and that is reclusion perpetua to death. Sa kidnapping with homicide naman, which is another example of special complex crime, kung titignan ninyo sa Article 267, the penalty is reclusion perpetua to death. Before yung Article 267, wala pang kidnapping with homicide. That's why there is an amendment under 7659, wherein it included the provision where a person or a victim is killed or dies as a consequence of the detention. Kaya dito sa kidnapping with homicide, ang specific penalty dito ng batas is reclusion perpetua to death. Then we have rape with homicide under Article 266-B, and the penalty is death. And because of RA 9346, the penalty will be reclusion perpetua to be imposed in lieu of death. Third rule, there is no complex crime when one offense is committed to conceal the other. For example, Akay went to the house of Odette to profess his love. Odette refused it for the reason that she was already in love with Lancelot. Akay got angry and choked Odette until she died. In order to dispose of the corpse, Akay set the house on fire. There are 2 crimes committed by Akay. The first is murder or homicide, as the case may be, sa pagpatay niya kay Odette. And then, there's a crime of arson, kasi sinunog niya yung bahay. Here, there is no complex crime, kasi arson is not a necessary means to commit homicide or murder, kasi hindi niya naman ginamit yung fire para patayin si Odette. Pinatay niya muna si Odette, and then sinunog niya lang yung bahay to dispose of the corpse. So in other words, he committed the crime of arson in order to conceal the crime of homicide. And under the third rule, there is no complex crime when one offense is committed to conceal the other. So that's it for this video. Thank you very much and good luck po sa inyong studies.